Nevada. We're already on.
Check here, there's some mute, but
Oh, okay.
Yeah.
So who would control it?
Joey,
Okay.
Joey or Ann?
okay.
Oh, there he is. Then.
Okay, buenas. This meeting is called to order. It's February 27, 2:33 p.m. In compliance with 5 GCA, Chapter 8, Section 8107, public notices for the Guam Ancestral Land Commission, land title hearing, continuation, and board meeting scheduled for Friday, February 27, 2026, were published in the Guam Daily Post on Friday, February 20, and Wednesday, February 25th, 2026, and posted in the Government of Guam Public Notice Portal and the GALC website.
And here.
Director, roll call.
Go to number 13.
Number 13.
Right there, that's correct.
And
What is it for the
the
title
pink, the
hearing?
pink, the pink.
Okay.
Yeah, right there.
Okay, that one.
Okay. The hearing will now reconvene.
The Guam Ancestral Lands Commission is now reconvened for the purpose of title hearing on applications for ancestral lands claim. Commissioners, please respond for roll call. The Guam Ancestral Lands Commission is now reconvened for the purpose of title hearing on applications for ancestral lands claims. Commissioners, please respond for roll call. Chairman Eclavea,
Present.
Vice Chairman Ronald Laguarnia,
Just to get,
Treasury Secretary Anita Arlino, excused. Commissioner Angela Camacho,
Present.
Commissioner Maria Cruz,
Here.
Commissioner Luisa Westling.
Here.
Mr. Chairman, there are 5 commissioners present. There is a quorum.
Posse Director? If I may, can I suggest, is this the first time I've been in this type of situation?
Okay.
I see certain people who are present, is it proper that we address who they are? Presentation.
I think we address that when the item comes.
Director,
we
address them?
Yeah.
Yeah, we do have some of the, we have our public. Oh, our attorneys present?
Yes.
Shall we acknowledge the presence of our legal counsel? Yes. I guess.
Mr. Chairman, I'm here.
Okay, then,
there,
yeah,
yeah,
but
respond.
then we will address the presence of the people on Zoom.
For recording purposes and while we file and for audit purposes, if you so desire to speak, you will have to turn on your video. Okay, Mr. Chair, we may proceed.
Okay.
So this looks like, not on the right page here, right? Number 15, I should be reading number.
Yes, number 15.
Yeah, yeah, 15 pages, number 15. Yes.
Yes.
Yes, sir.
Right here?
Yeah, right there. Yeah, so we just, we're gonna reconvene
Okay, we're reconvening, okay.
and we'll call the applicant. Next lot.
So I have to say the lot number, right? Okay. Okay, this, I'm gonna list all the lot numbers right. Okay, having heard the various presentations on the application or title for lot number 1049, lot 2240, and lot 2241. The commission stands ready to vote.
Or should we discuss
Yeah.
first?
Yeah.
Yeah,
So
right, we
we're
need
just
to
gonna move
discuss.
into discussion, yeah. Okay, so we're gonna invite the family members in for their testimony.
Yeah, and then at the time, Mr. Chairman, and I think when they do come in, then we will, have Joey, right, to address the matter of concern, or is that, is this a continuance from last meeting? Oh, okay, so the concern has already been heard.
Yes,
Okay.
we've already heard their
Okay.
testimony and
Okay, so I
we're,
wasn't
yeah.
here, so, okay. All right, as long as it has been heard already.
I think you must have been here.
No,
Because
the
it's
last
been a while
meeting
back.
I was in.
I wasn't the last meeting.
Oh,
Yeah, it was way,
priorly,
yeah,
way
way back, yes, yes.
Yes, okay, that's all I wanna know, that if the concern was already addressed.
Yeah, we just ended up tabling and everything.
Okay.
Make yourself at home. Feel comfortable. Feel comfortable. As long as we can have some too.
The chairman.
Yeah.
Make sure that these people here that are here now, are enough to introduce themselves and what is their,
Yeah.
what, yeah, are they observers? Are they family members? Or just general public?
That's where it is.
We need to know who they
Yeah,
are,
to describe. So,
because I see a lot, I see quite a few here. And that when they do it just themselves to do their video.
Yeah.
Just look at that, I don't see them, who's this Del Royal, Redi meeting, this one, Chill and JPL. Who are these people? We don't know. Okay, you get that back, you know,
yes, exactly. Vice Chair.
because we need to know what these people. Have ulterior motive.
So we have to say their names again.
Yeah, that's right. For the record, for the record. Just to reminisce again, you know. And just notify them that you're doing all three at one time. Yeah, because it's the same extensible on that.
Right.
All the lots.
Yeah, no, it's the old business.
Hey, Joe,
Yeah, yes.
and it's on the new property. Always there, verbal card shoulder.
We did, this is a continuation again.
But your concern, they're asking to use our property and it's.
I'm fine.
Huh?
I'm fine.
You sure?
I want
No, but make sure that ours doesn't end up being unused.
Yeah,
Really,
man.
not only that, it's unused. Don't ask you for a fine. But make sure that we don't suffer the consequences when it's time for.
We have to make sure it's usable.
Exactly, you know, it's not gonna be a wasteland, right?
Don't want that name. I don't, yeah. So
Yeah, isn't that name don't have to be.
not to put us in a predicament.
Really exact. That's all I'm concerned about.
I think we're just, We're waiting for the video. Yeah, it's okay.
And we should do a. You guys do a map on this one?
The last one.
We should do a presentation.
They did put a.
Oh, yeah, really?
Yeah, they did.
Okay.
Yes, but we didn't. I couldn't.
We didn't have
That's
that.
why we're continuing.
Oh, okay, okay.
That's why you're here.
But there it is, right?
It's again, yeah. That's it. That's the one.
Okay, we should mark it in yellow. I mean, where's the existing thing versus the proposed?
And it's been a while, no, that we.
Yeah, we've been a while. That's why I'm just.
It's again, it's like this.
Yeah, I mean,
Yeah.
they go to revenue. Get up to the law.
Shit.
And then we'll fix the things.
Yes,
Yeah.
you're being recorded.
Yeah.
Oh, I'm sorry.
Oh, there we go. They're on. Okay, can continue?
Mr. Chair, so we're back, and we're continuing the land title hearing for lot 1049 Barrigada, lot 2240 Barrigada, and lot 2241 Barrigada. So all the applications were gone through, all the exhibits were presented and submitted. I'm sorry, submitted and presented. And now we just need the board to make a decision on the application, whether to grant title, grant the application request to either Gabriela C. Titingphone or Ignacio C. Titingphone.
Okay.
So I don't know, Commissioner Westling, I don't know, did you still have any questions? The last time I believe you brought up that you were gonna get a title report, or did we want to go ahead and just?
I did, I did, order and bonus report, on the properties and, put together. Sorry.
Repeat,
Yes,
repeat.
Joey, to answer your questions as to whether or not I have any additional questions regarding this application. And you did ask if I had ordered any title reports, and I did. But they were basically owner's encumbrance reports, and I ordered these from Security Title. Just to help me to understand the process and the ownership. And also taking legal counsel's recommendations that he addressed my questions. At this time, I don't have any additional questions because I understand the rationale that he gave in his response, in that as far as the commission was concerned, he did write here that the title should be issued in the name of the estate of Gabriela Cardenas Titingfong. But there were several reasons why. He said it should be done that way as far as the commission is concerned. However, that the commission should, advise and counsel the claimants, the families, the heirs, of the, steps that they need to show and prove, in order for our conveyance to be final, because there are ramifications as far as the heirs and any claimants to the property that should be vetted and satisfied prior to any final conveyance of title. So I understand his rationale, so to answer your question, I don't have any other questions at this point.
Very good, Commissioner Wesley. Joey, do we have anything else to add? Because this is basically the ostensible owner, right? That was the military took it from.
Yes, so the way the attorney, I guess his opinion was the owner at the time of the taking was Gabrielle. And then he feels that we should just follow the chain of title and deed it to that same person.
Okay, do we have any other questions from the board members before we get some testimony from the family?
No questions, but can I just bring up, I was asked to mention that at the last hearing.
Sorry, can you turn on unmute yourself?
I was asked to just board know that at the last meeting, Charlene Santos Duban attended the last hearing, but because of deaths in her family, in her immediate family, she's unable to attend today.
Okay.
But I believe she might be on Zoom, I'm not sure.
Okay. Okay, thank you. So, any other questions from the board members? Huh? Okay, Commissioner Wesley?
I don't have a question, but I'm just wanting to check with my fellow commissioners. If you have read the legal counsel's recommendations, and if it was at this point, do you think it's prudent that we do counsel the heirs as to what steps they need to take and what they need to do?
Well, I think, I'd like to hear, if they have anything else new they want to say, and then we'll bring bring up the legal counsel's recommendation. And is there anybody new from the last hearing? You were here the last hearing and the same? So we don't need to, we have to remind them that they're still under oath, right? So you're still under oath?
Joe's Snob is in Hawaii. He has a court hearing, federal court with the judge. And then Rita Laguarnia, her husband's getting medical care in Hawaii, and she probably won't be back till May. So we did chat with them once Joey sent that email, like in a few minutes, and we have a chat through, on WhatsApp, and they told us that they couldn't attend, but for us to attend and represent, that type of thing. So, there's nothing new. We've just been waiting patiently for you all.
Okay, thank you. Considering that, I think what we should do is, go ahead and continue with what Commissioner Wessling was, just brought up on her last statement, that we'd like to get you to, understand what our legal counsel has advised the board. Okay, and this is an advice for the legal counsel. And so, are you aware, are they aware of the legal counsel?
No, they're not.
And we should definitely, state what our legal counsel was advising the board, yes? Or should we have our legal counsel just do it himself here? Legal counsel?
Attorney Miller? Attorney Miller?
Mr. Chairman, that advice I gave you was quite some time ago, and in full disclosure, I don't have it in front of me. So since you all have it in front of you, if you all could just share it, and I'll tell you that's exactly what I meant.
Okay, I'll go ahead and read out the legal counsel's advice to the board, and then if you want, you can respond.
Okay, and
Okay.
will you?
We can give you a copy of it
Thank
too.
you.
Yes, okay. Yes, can we give them a copy real quick? You can give them a copy? Okay, this is from our legal counsel, Attorney Miller. The short answer is that the title should be issued in the name of the estate of Gabriela Cardenas Taitingfung. According to the file, Ms. Taitingfung is the ancestral land claimant. Titling the property in this way gets the claim off the books of GALC and leaves the matter of who are the living human beings allowed to use or convey the land to a future court action involving the actual heirs. To follow up on our discussion of this topic yesterday, 18 GAR 9304 says, where a claim application is made by anyone other than the original landowner, which would be the case 99.9% of the time, the applicant will present proof that they are entitled to pursue the claim on behalf of the estate as the administrator or executor. Conveying the claim property has critical implications for not only the applicant, but others, generally family members involved. 21 GCA 80104C provides that when the GALC conveys a deed that does so subject to the grantees, heirs, successors, and assigns forever giving up any other claims to ancestral lands and related compensation. Said another way, once the GALC decides to turn over a property to someone, not only does that someone give up ancestral claims, but all their relatives gives up their claims as well. As we know, there is more than one instance of an applicant obtaining a deed that promptly turns into a lawsuit amongst family members. The GALC has adopted a couple of rules designed to prompt family members to settle these differences before final action by the GALC rather than after. The first is the rule that requires an applicant to prove at the very beginning of the process that they are legally authorized to speak for the original landowner. I don't pretend it will be easy, but let's use Ms. Taitingfung as an example. We start with Ms. Taitingfung because we have court records from 1950 that show her estate was the owner of the subject parcel. We have additional court documents that identify Ignacio Taitingfung as the heir of Gabriela, who takes the subject lot. I don't find any paper in the file that identifies whether Ignacio is alive or passed, and if he's passed, he named as his heirs. Per Rule 9304, Eleanor Borjas should provide us with that information. I note that the file seems to show that Ignacio Taitingfung has 3 sisters. The file doesn't show any information as to Ignacio's spouse or any of his children. That needs to get sorted out. Under the law of interstate succession, if Ignacio has a spouse at the time of his death, all his property would go to the spouse. Perhaps the spouse remarried. Perhaps Ignacio and a spouse had 4 children, but one died before Ignacio. Did Ignacio want his deceased child's heirs to receive a share of his estate, or did things only go to the living children? We could conjure many about this. What about that scenarios? The key takeaway is that application of R 9304 puts it on the applicant to get all of this sorted before the GALC puts in a lot of work to vet the claim. Requiring the applicant to get this sorted up front is reinforced by 18 GAR 9321. This rule requires the GALC to ensure that all parties whose interests may be affected in the extinguishment of an ancestral claim are notified in writing of a pending GALC action on the claim. The only way the GALC can ensure that notice is provided is for an applicant to supply a list of heirs as well as proof of mailing to these heirs of various notices of GALC action. Before the GALC takes an action that has the legal effect of foreclosing anyone's ancestral claim, it should have these proofs of mailing in the record. These statutes and rules don't create additional work for GALC staff. They do create additional obligations on the part of applicants. We recommend that GALC staff counsel an applicant that they should put together not only family trees, but also evidence of how these deceased aunts, uncles, fathers, mothers, etc. has disposed of their property. GALC staff also needs to understand who might be the property owners if the claim is accepted, so that it can ensure that all these individuals are aware that the GALC is considering taking action on their property.
Mr. Chairman, in sum, what I used a lot of words to say right there is that the intention of the law, the intention of the regulations is that the commissioner should be able to draw a straight line between the original property owner and the person you're considering vesting the deed in today. To the extent that you can't draw that straight line, to the extent that commissioners have questions because there are gaps in the information, that those gaps need to be filled in before we vest the title in somebody other than the last person for whom we clearly understand owns this property. We clearly understand who owned this property in 1950. So we can, if it's prudent, we can vest title in that estate and have these folks, sort out the chain of title themselves from 1950 forward, or we can take no action today, let them gather all the appropriate information so that we can draw the straight line and you all can see and understand the straight line between Gabriella and whoever we're going to vest title in 2026.
Okay, understood?
So we know that they didn't have children. So I have Ignacio's just, funeral announcement. Anna's, there wasn't any published, that I could find. But I know that, we know that they did not have children. I also have like census up to 1950 showing they didn't have children. And Anna, at the time when Ignacio passed away, she was at St. Dominic's. And she was getting care there. She died just a few years later. We can get death certificate for you. I do have like all of the everyone census information, also who the sisters were, the brothers. Then we also collected all of the information of every person that was born, their children, so forth, until this time. So we have all of that for you. We can give you copies for that. But if you do need to have like a copy of the death certificate or both of them, when they did, but in proof that they didn't have children, we all know as family they didn't have children, and if they did have children, of course they would be forward, I am sure. But we know that they never had any children. And then, like I said, up to the 1950s, it will say that they're together, but there's no children, even from the time they were married. Was that suffice in information for you? Or what else would you think that you would need?
Well, our legal counsel is, advising the board to, deed the title to the estate of Gabriela Cardenas Taitingfung. Do you have any, reservations about that?
No, no.
Okay, then I think that won't really make any,
Oh, okay.
difference on, yeah. So if you have no issues with that, then we probably can do that today.
That is what the family wants.
Okay.
Or, that's what we're hoping for.
Okay. We have a question from our
Yes,
vice chair.
I'm on. In lieu of your sightings of family members, can you, do a chart of the families? I mean, a listing of, like a functional chart.
So like a
That's,
family tree.
yeah, it's a tree to identify the,
Say, for example, my grandmother, who's Joaquina, which is one of the siblings,
okay,
a daughter of Gabriela.
Yeah.
I want a family tree of hers.
yeah. That way you would identify the chain of command as to how it would go down in the event we might have in the future. Event that, yeah,
Okay.
It was submitted in the.
it was already,
Yes,
it's already in, it's in it, okay, that's, but it's not in a chart
It's
form.
not in the chart, no. You want to.
Yeah, it would be good under the tree tray, yeah. That
No,
would
but
be,
wouldn't that be required, something we would require if we were not needing it to? If we were not, then we would, but if we're needing it to the.
To Gabriela.
Yeah, other than Gabriela, then yeah, he's gonna be, yeah.
But it's gonna be needed according to
Yeah.
the
attorney.
for notification.
right,
But he's saying that that's gonna be the applicant's.
their responsibility,
Responsibility.
yeah.
So you make your chart, and then you have to submit your chart to us as how you notify these family members
Yeah.
of the hearing.
Of today's hearing.
Also, I think I'm hearing that they need to agree to this action, that they agree to us. Methods to, be compensated, right? Whether it's returning the land. So I think we also need to know if they agree to this action. Is that?
No, not really.
No, well, I think that's why the purpose of the application is they're requesting for title. So
Yeah.
that's, should be understood already.
Yeah.
We're granting
We've
title.
never done that, we've never
to
done that. They
the-
just come and give, that they're claimants, we like you to deed this property to us. So we deed it. We always, we never ask them if they want other compensation as, yeah.
Well, when you deed it to Gabriela's estate, then any other member or heir cannot say, I didn't want that, I wanted.
Wait, can we go ahead and unmute you? I'm sorry. Right. So the process is normally the board makes a decision. And then there's a notice of an award. That's where the 10-day appeal process comes in. That's where if anybody wants to contest the decision, then they'll have 10 days when the notice has been made. So I think that's where the opportunity comes for somebody to say, no, it shouldn't go to Gabriela, it should go to so-and-so.
Or I don't want it
Yeah.
returned to Gabriela's estate.
Yeah.
I prefer.
Was it, I mean, isn't that the two choices was Gabriela or Ignacio? Those were the only
That's right.
two that you advertised that it should go back to. Am I correct?
Yes.
Yes, okay, so I understand, but the errors, there's no errors in Ignacio. There's no children. Both Auntie Anna and Uncle Sol passed away. So in our minds, we're like, okay, since they're not here, then it should go back to Gabriela. We're gonna have to take everything and do a probate for her.
That's right.
List everybody in the family for the judge, give all of that to, to the lawyer or whatever it is that we need to do, in the process. So, yes, I understand there's a 10-day window from today, or however your decision is. And then whoever family members want to make a discussion and file that they would rather it go to Tom, Dick, and Harry, whoever that might be, then you guys would meet again to say, what should we do? And is there documentation proving that it should go to that other
Well,
person?
see, what would happen when you take it to probate court, that's where everything gets ironed out.
Correct.
They're the ones that's gonna find out who and what. We're out of the picture.
I understand,
know,
but
yeah.
that's why I'm saying on your 10-day window, right? Some other person in the family or heir, am I correct?
I
Correct me
think
if
it's
I'm wrong.
anybody in general.
Right,
that wants
anybody
to
in general
accept
can
it.
say, no, I wanted to do this, but they have to turn in documentation and
Yes,
proof.
they have to-
Yes.
And then you guys would have another meeting to.
Yeah,
discuss.
which is
The way the
highly
law- That's the way the laws. are.
Yeah,
Right,
which
so
is-
I'm trying to just understand what's gonna happen.
Yeah.
So, I understand definitely the 10-day window for someone to.
we,
make an appeal.
we focus on returning the properties back to who the federal government took it
Correct.
from.
And
And
that's-
apparently that's right, and for somebody to come in and let's say, challenge that,
Right,
they gotta really have some, substantial evidence why, because, but even if they did, and that, you know, it was stolen or whatever, if the military took it from this person, we're obligated to give it to that person.
okay,
Then you gotta fight it in court with whatever the case may be in that situation.
okay.
So, yeah, so even if somebody came in and made an objection, they gotta, it might not really stop us from giving it to whoever the military took it from.
Mr. Chair,
Yeah.
okay, from the very beginning, when we found out about this excess land to be returned to the original owner, and we saw this on the advertisement, so we called a meeting of all the heirs that are on island, and, each clan, we voted, because you don't want 150 people in here. So we minimized it down to a representative from each clan. And that representative is responsible to disseminate that information down to the lowest person in that clan. So, like every meeting, every time we receive something from Joey, we send it through WhatsApp or email, and we also send them the link. Like, I told them that if you're interested in listening, here's the link. And so nobody is left behind. Everybody, but we minimize it down to, because there's 5 clans in this Gabriella's family, yeah. So,
Okay, understood, very good,
yeah, so,
very good.
yeah.
So if there's no
further.
yeah, we do have a recommendation from
Yeah,
our legal
and
counsel.
also we have a listing of all the children, their email address, their telephone number.
Their mailing
Ev-
address,
Everything is,
Yeah.
we have it all, yeah, so, yeah.
Yeah.
Oh,
We wanted to
yes.
make sure that we got
Um,
all the
I mean, we've been
information
working on this since,
from everybody.
what,
Right.
2022? Yeah,
Okay.
and, Claire is
Okay,
my assistant, so, we work, I really give her a lot of credit because she's very, I'm a computer illiterate. So she's very good in computer. I give her all the information and she, put it all in, spreadsheet, everything. So it'll be clear for everybody. Now, we haven't given all the family.
Can you go ahead and identify yourselves again? Identify yourselves again?
May you identify yourselves?
Again, one more time for the record.
Okay, I'm Eleanor F. Borja, and I am the applicant or administrator appointed by the Gabriela clan to represent them.
Okay, and your,
I'm Claire Cruz but anyways, I am.
She's my assistant.
Yeah, I'm a granddaughter of Joaquina Titanfone Arceo, who is a daughter of Gabriela.
oh, I see, okay.
Yeah.
Okay, got it.
We wanted to get the connection.
Yeah.
Yes,
Okay.
I asked you.
Okay, well, we're practically ready to act on your
And I'm a
request.
daughter of,
Yeah.
of
And,
Mother-
Unless there's any other questions from, I'd like to first approach the board. Is there any other questions? No further questions?
I have a question before the board makes any decision.
Yes.
Joey?
Yes, ma'am.
Okay, I noticed that on your email, you've been emailing Shannon Titano?
Yes, ma'am.
Okay, just to, for the record, Shannon is not representing Gabriella's clan. Shannon is only representing the Leon Guerreros, you know, like Corina, what's her name? She's Charlene. She's only representing that clan.
One of the 5 clans.
Right, but we have our own lawyer for the whole clan.
Understood.
Yeah, okay.
Okay, that's
But
clear.
I appreciate because they've been, you know, you've been sending her email and I was wondering, how come she always get email and we don't get email? Okay, if you want to get email, I'll tell Joey to put your name down.
Yeah, as long as
Yeah,
they requested
Yeah.
to be notified, so.
yeah, anybody can get an email. There's no secret.
Notify you,
Yeah.
yes.
This is, yeah, all public information. Okay. Thank you, Mr. Chair.
That would complete your
My
testimony,
God.
right, for the whole
Yeah.
hearing this year. Okay, so board members, discussion or somebody make a motion?
Been here the last meeting.
Even you can still. Okay, Commissioner Cruz?
Commissioner Cruz.
Hang on, one second, I'm sorry.
Did it die or?
Your thing. Is it on? Okay. Okay. Okay, hang on.
You have to unmute.
Thank you, Joey. Can you go ahead and repeat? We do have Commissioner Cruz.
I'd like to make a motion to approve the application on lot 21049 Varigata, lot 2240 Varigata, lot 2241 Varigata, to the estate of Gabriella G. Tackinson. Based on documentation presented to us on the ownership, the property was condemned by the federal under the name of Gabriella G. Tackinson.
Gabriella C. Tackinson, correction.
Okay, the motion's on the floor to approve the applicant's request for the return of these lots. Do we have a second? We need a second?
Commissioner Westling seconds this motion.
Okay, seconded by Commissioner Wesley. Discussion? No discussions? Okay, all in favor? Aye?
Aye.
Aye.
Aye. Aye.
Any nays? No nays? This, the request of the applicants passes? Congratulations.
Thank you. Thank you.
Okay.
No, wait, it's.
The closing.
Oh, yes, yes.
This one.
Okay.
So,
No,
I think. Yeah, so the old, the way we used to do this before was we would publish the ad,
Yeah.
notifying, publishing, the board's decision. And then normally we take that as notice to the public. So I wanted to check with Attorney Miller, is that still fine? Or do we? Is there something that we need to do other than how we used to do it before? So, you know, again, for us to save, costs on mailing everybody, we felt that publishing, notice in a newspaper of general circulation was sufficient, and proper notice. And so,
Yeah, I think adequate notice is, excuse me. If you publish the notice of the proposed deed issuance in the same way you publish a notice of a GALC meeting, I think we'd satisfy the requirement.
okay, great. Okay. So then, Mr. Chair,
Yes.
I guess we can go ahead and, we'll basically to the public, now that the board has, made their motion and, it was approved and adopted, our next step will be to publish an ad, to, notify the public of the board's intention to deed the properties to the estate of Gabriela. And then there'll be a 10-day appeal process after the publication. So after that, publication, there's 10 days. If nobody, contests it, then from there, we will schedule a deed signing ceremony. So, just give us some time to publish the ad. And then, from there, hopefully there'll be a deed signing ceremony.
So you just send us a quick note, about what day the ad's coming
Yeah.
out or when it came out.
Yes,
Like you normally do.
yes.
Trying to do that.
We can share the ad with the family.
Yeah.
right?
Yes, and then we send it, we'll send it,
Yes.
that ad to all of the,
Yes.
Yes. So it'll be public.
our 5 families, and then they can send it all. to them. Okay. Thank you.
So do I read?
Yep. So this says that, normally they have to.
Yeah, pay a fine,
So,
please.
not necessarily.
Okay.
Yeah.
Just the closing, the last.
The closing night
The
last
thing.
The last sentence, which is.
to invite all the family.
So just.
Speak aloud.
Skip the first sentence.
Yeah.
I guess after the,
Okay.
after the.
Okay.
After the 10-day.
After the publication of the ad, then you would put the 10-day appeal period begins. So instead of after today, just put after the publication of the ad,
Okay.
and then we can.
Okay, here we go. Okay, so after the publication of the ad, the 10-day appeal period begins. Please see the executive director if you have any questions on the appeal period. If no appeals or protests are registered, staff will arrange a deed signing ceremony as soon as possible at the end of the appeal period, subject to scheduling. A public notice will be issued and staff will also make personal notification to each applicant. Thank you for your presence today, and we look forward to seeing you at the deed signing ceremony.
Thank
Yeah.
you.
Motion to adjourn.
I was-
Motion to adjourn the title hearing.
Okay.
We have to adjourn the title hearing. so we can-
But before we do that, I would like to comment,
Yes, sir.
on behalf of the ancestral lands. We would like to, on doing we haven't done a deed signing ceremony in quite some time. So it would be a great opportunity to bring all the clans and the family there during that event. Because it's a big ceremony that touches not only the families, but it touches us. Because this is our role to do this, to do the injustice, right? And you can see the change of the face when they sign it, and that's the good part there.
Yeah.
You can see the injustice, right? That's my point, and invite everybody in,
Exactly.
and you'll see at that event. Yes, we will, absolutely.
Everybody from
Somebody from Maine,
Yeah.
a lot of our family doesn't. appeal.
Yeah, and they can do Zoom too as
We
well.
can do Zoom or.
And then, if they do have like how you do the YouTube or the Zoom.
Yeah.
And have them come in, that would be wonderful too.
And the governor, and they'll be there to sign off, and that's the good part.
Yes.
Yes,
The
Most
location, we'll
Yeah.
work it out.
we'll work it out. We'll let you know based on the governors.
Okay, we appreciate it.
Yeah. Thank you for your presence.
Thank you.
Congratulations, yeah. Yeah.
Okay, motion to adjourn this
Adam.
hearing?
Yeah, well, so move, Mr. Chair,
This, title hearing is,
just for this year.
Okay.
Okay, congratulations. See you then. Yeah, I see you. Adios. You have to mention that.
Yeah.
That's a good part, man. You see their face.
Did,
One.
remember this?
Oh, but I wasn't there. Yeah, that was right. But I was a while back and I wasn't there. I couldn't make the company.
I
But
think
you know
we're still,
that-
the title hearing.
Beautiful. That's what I
But we're
like.
still in a
It's
We're still actually
settling
for-
of justice.
For old
That's a good
business,
one.
item number 4,
That's a good one.
old business.
Right on. Yeah, you gotta remind them. Yes. No, they did one day, they did one day. But I wasn't there.
We did.
What about last year?
Where?
Sorry, brothers.
Tiaco.
Oh.
Lim Tiaco. Remember?
Okay, Chalo, right on, congratulations, my brother.
When did we do Lim
Yeah.
Tiaco?
Congratulations.
Yeah, nahi, pamilya, nahi. Okay. Okay.
3 years? Wow.
See, they're lucky, man. Us, we didn't even get it.
Okay, we're gonna move down to item 4, old business. A, estate of Jesus Ignacio Ogden, lot 184 and 196 PD, request for revised easement to lot 190 PD. And Joey, you could
Yeah.
go ahead and give us another update on that and how it affects our property?
Yeah.
And is it advantageous, right? If it's gonna be an advantage for us to do so, or is it negative, or?
Yeah.
Remind us again?
Enjoy. Yeah.
So we call the family?
Ah, okay, so can we have the family?
Oh, yeah, bring the family up.
Buenas.
And, is it the same people? So need to,
Are they in the familiar?
Oh.
Buenas.
The heirs of.
Can you guys hear me?
Ignacio
Okay.
Buenas again? Welcome.
Buenas.
Pare.
Stuswasi pare champan midzu.
Yeah.
We also have Jerry.
Yeah, Jerry's online.
Can you hear me?
Yeah.
There's a few of us, the heirs of Ignacio, Jesus Ignacio again online.
And
I
we're-
believe Chris Hill and Carmen from Duenas Camacho and Associates, I believe might be online too.
Yes, I'm online.
Put their face on. Yeah, no, I'll go next, Mr. Chairman.
Thank you, Chris.
Put their face on.
I'm gonna be leaving
For
in
the record.
10 minutes to another meeting, but Carmen will be listening in.
Okay, thank you, Chris.
You're welcome.
Does anybody don't have their cameras on? I think everybody's on. Joey?
No, there's several that are.
There's Liz Laguardia, Meow
Jill.
Boy, Jill, and a Carmen, and a JPL.
Yes, can everybody please turn on their cameras?
Except for the auditor.
But I think they're waiting for Carmen. I think,
There's a chill.
Chris will be leaving soon, so Carmen's going to be listening in.
Oh.
There's Liz going. I don't know where we'll see it. Wow. What's again? Is it record?
so Jerry, do we wait for Carmen?
Carmen said her camera, she doesn't have a camera available,
Okay.
but she's listening in.
Okay, commissioners, we're on the map, right? I can see everybody's on the map. Joey, I guess we'll, form us on the, right, on the easement.
Yeah, so again, we have a letter submitted by Geraldine M. Pinko, addressed to the Ancestral Lands Commission back in September of 2025. And basically, they're requesting to revise the proposed master plan because the current proposal, I believe the easement runs along a steep cliff. And so they, with the help of a surveyor, Hill, he drafted two proposals, which are attached to her letter. And basically this proposal would, I guess, make it more feasible to construct the, or if and when the easement is ever gonna be opened up, it would make it easier to open up the easement. Should I read the letter?
No, it's okay. Commissioner Weston?
Yeah, Commissioner Weston, just to clarify.
Between the two maps, scheme A is the current, proposed easement for the tentative master plan? Is
No,
that
no,
correct?
No. Scheme A is the first proposal, and then scheme B is the next proposal. The difference between the two is, well, the scheme B provides access to another lot. Versus scheme A, it doesn't provide access to one of the lots that would be landlocked. Doesn't really show, I'm sorry, doesn't show the lot number that I'm referring to.
Okay, so the revised easement route through lot 190 PD is it one of these schemes or not?
Yes.
Yes?
Yes.
Is it?
Okay. Most of that. Neil, could you share screen? Is it possible?
I believe it's through
190,
184.
So 190 is,
There's the one on the top.
Let me share this.
Yeah.
but on this lot.
Oh, okay, so they're proposing two potential ways to,
This is 190,
Yes.
okay, that's fine.
Gonna go through.
There you go, okay, that makes sense.
okay, and so,
Okay, but this is the old one.
There are two, there's
This is
two
the one
way
that-
outs,
this
yes. This one doesn't provide
Yeah.
access to this.
Yeah.
no, it
First,
provides.
first is, first,
It's cliffside.
first is
Okay, but
more
this still
is
has, okay, this would give it more
Ladder.
flatter routes, but that's through. Okay, so what does our tentative master plan proposal show, just so I can compare?
The two maps are just two proposals, or is it one is existing right now?
Those are, I believe they're both proposals.
Oh, that's from the family?
Yeah,
I see.
that's from the surveyor. Because we are already in the process of surveying both the properties itself. So we just need to revise the easement into 184. And when we visited with Joey a few months back, we were just looking, we were actually looking for a bull cart trail that's supposed to have been in existence. But just finding out that we would have to probably revise the easement and seeing that 190 could be a possibility to lead into our easement. So that's the request that we are putting out.
What happened on our last question?
Yeah, share my screen. So basically at the last meeting, because Jerry wasn't present, and the brother was here, you guys requested to have the actual administrator come before the board.
Okay.
So that's why we table the matter. And so let me share the screen now. So this is lot 190. And this is the current plan here. And so
Polaris,
Polaris,
right?
right?
Yes, cross Polaris.
So this is one of the boundaries of lot 190. This one here. That's one here. So when land management did this proposal for ancestral lands commission, it wasn't based on any field work. It was just based on they call it tabletop map. They didn't take into consideration the boundaries, the contours and everything like that. So what was approved, basically what across this or cut along this boundary of lot 190, and then it will go this way. And as you can see, it's a ravine or a cliff or the side of a mountain. So what they're asking is if the board can approve one of the proposals, and the proposal basically is just cutting along here this way. So it would come, I'm sorry, it would come here. So this is the existing road. And then it would cut through here. And then across here. And then eventually to their lot, which is here, 184. So I don't know if that makes it, if that helps any visually.
What question, which scheme would that be? Scheme A or scheme B?
Neither.
Scheme B?
No, this is neither. I didn't.
No, she's talking about when you went and cut across,
When so
when you
which
when you
scheme
drew out
if-
that scheme B, I believe.
Yeah, if the board was to approve, which scheme would they be looking at to?
So I would
Right.
suggest scheme B because scheme A does not provide access to this lot.
Mhm.
So which lot is
Their lot is one right here.
184 and 196?
Yes,
Where's one, that's 196?
yeah,
Oh, they're together.
yes. It's just it hasn't been plotted on this layer, so,
Yeah. Is there any drawbacks or any negatives or? Behind it?
No, and so if I'm not mistaken, the surveyor also said that the way he drew up the plan was he made sure that there was enough space to that the ancestral lands could develop the property.
I think in the long run, we are going to have some problems because it's, the initial, based on there's a whole area, not considering the properties that's already been conveyed. So this is, we were really bound to stumble into this kind of negotiation.
Yeah.
How does that affect all those other properties there, Joey, down further down towards the page? Oh, they have access down here, right? Because there's a road down there. There's a road that provides it there, right, at the bottom of the page. I don't see any issues.
I remember, or that was a while ago, so.
I think it'll be beneficial for us if we get the scheme B, because then the surveyor has already stated that, he plotted a proposed easement where ancestral lands could still develop the
It
property.
takes it away from the cliffside there.
Yes, it does, and it also gives access to the other property. It gives access to other property owners in that vicinity.
I'm good with it. I have no issues with it.
Lot 196 is this bottom area right here? Okay, so it's not fully shown on here, right? Okay.
184 is sort of the point right now. the
Got
point
it.
of discussion.
Got it.
196.
Yeah.
Later, okay.
There is gonna be from the map itself, there is a proposal to access
196
Through this.
through 184.
And Joey, we're not transferring any easement at all. There's no easement there right now.
No.
We just need to put it, we're putting in an easement.
I think we're realigning there's current easement on the property, but it's toward the cliff line.
Also, I thought that was conceptual. No, that is an actual easement?
That's what's on the master plan.
Oh, it's on the master plan, but is it an actual easement?
No.
No,
Oh, I
it's
see.
a master plan on paper.
Oh, okay, okay.
But the way they
They just didn't take into account that the rain and everything, they just did it with,
They didn't do an actual, tabletop.
tabletop. That's just-
There was never a bull cart trail there?
No.
No.
So what was their access, prior to all of this? During,
Was there any
at the time
access?
of takings?
You notice, you know, of any history of the access?
Yeah, Castellan Mizune, what was your access to going in there?
We always heard of a bull cart trail, but then now we know there isn't one.
That's what we have to provide.
What's the size of that, Joe?
2020?
We would. We would have to ask the surveyor if they can calculate. I mean, I could. You want me to roughly calculate, but I don't have that information. I didn't prepare the map.
Regardless of.
It'll be a 60 foot or 100
Yeah,
foot?
usually it's like, I think 15 on each side, right?
30 foot?
Something like that.
I think
yeah.
it's,
No, yeah.
Something like that, yeah, 2020.
the surveyor's online if you would like, if you want to ask him.
Yeah,
Yeah.
What was the, or
what is the
Or
request
Carmen?
for on the east?
was that based on 40 feet?
40, yeah, it's 40 feet.
40 feet
Yeah.
wide,
Yeah, 2020 on each side, 2020
but it's gonna be 40
total,
all.
right?
No,
That's what.
actually,
Central lines, 'cause normally it's
the
40
one
on
that I
one
proposed,
lot and 40 on the
Oh,
other.
wow,
If it was to follow the boundary,
right,
but this is all crown land, so it's gonna be all 40-40. The whole 40 will be
within the 180.
190.
Not 2020.
No, because it's all.
No, because it's all one lot. I mean, it's going through the middle of the lot. Normally, it's 2020, we would between, say, two lots, two different landowners. So they would cut, they would follow the boundary, 20 foot on one landowner and 20 on the other. But this is going entirely through 190, through the lot itself, so it's gonna be 40.
Most likely 40, yeah.
So Joey, what you have on the screen is the master plan?
How big is the lot?
How big is our lot, Joe?
Well, I like the idea that it's gonna provide access to the lot next to it.
I think it's advantageous. Us as families and. Close it down.
And it takes away the proposal away from the cliff.
Yeah.
Who owns the bottom of the cliff there on the other side? Because it's gonna be 20 on one side, 20 on the other, right? Joey, if we get left it at the cliff?
I believe it was, because it was a crown lot. What land management normally does, if it's crown lands, they put the entire easement within the crown lot. They try not to take any land
Oh,
from a private lot.
okay.
Well, that's very generous, which is.
The cliff on government property.
Gotta be done.
So according to this, the lot is 19.8 acres, lot 190.
19 acres.
So just to clarify one more time for myself, so the master plan for easements is just a proposal, none of this is recorded.
The master plan is recorded. Yeah,
It is recorded?
yes,
Yeah.
And so then these easements then are recorded easements.
Yeah,
but the way that management titled it is it's tentative, meaning it allows us to make changes if needed.
Okay. Okay,
So it's
so there's
proposed.
we don't have to do a remapping and all that stuff?
We should, and, we could probably, not probably, but what we would do, instead of redrawing the map, maybe we can reference in a document that, this, proposal done by the surveyor, reference the master plan,
Yeah.
that this supersedes or updates or amends the master plan. But I mean, we could, I think we should redo the master plan now that we can or have access to software that will show us where, you know, we should and shouldn't make changes.
I have a time, if we could, maybe redo it case by case then, because it looks like we may be, getting more requests as the properties are being, you know, subdivided. So instead of having to record, the whole revised master plan, just record that portion which we need to revise, because if we're going to provide that easement.
Well, that easement just covers their lot. Right, but it also extends to all the other lots there, because there's already a road there. Yeah, so any other easements that's in their property, they're the ones who's gonna have to provide that easement to when they divide it up themselves or outside of that. Yeah, we're
So
just providing.
the current master plan takes care of anybody being landlocked. That's,
I know.
but what they want, again, it's because it's along, you know, you need to
Yes, right.
revise it, so that's what it is.
Okay, no, I was just wondering, like I said, I know you just can't, you know, just arbitrarily change a recorded easement, you know, there are new maps and new filings, new approvals all have to be done, so that's what I just wanted to clarify the process, because earlier somebody said, we're just realigning, and I said, well, I want to make sure, you know, is it really that simple? So you tell me that the language for the master plan allows us to make changes easily without having to go in for full, you know,
So this master plan
remapping.
will help guide land management. When these lots are subdivided, they'll follow this.
That I understand, and
Yeah,
I
so,
understand.
because without this, land management, they weren't,
Correct.
so
Yes.
this is just for them. When and if like 190 is ever surveyed and subdivided, they would follow that, but we can, like I said, we can record a document that will then reference,
That would allow the change from the original.
Yeah, that would
Okay.
point land management to follow. This is the amendment to, that will reference that document
Sure.
number, just to affect that specific lot.
Sure.
So we
Okay,
can do that, but
Okay.
again, this is not this is not surveyed. These easements haven't been plotted. It's just a master plan, just
Okay.
to,
And that's what I wanted clarification on, because, and I know tabletop surveys don't take into account topography of areas, and historically, there have been a lot of private subdivisions that have now, you know, remained, you know, 40 years later, nothing can be done with them because they were tabletop surveys, and I understand the family's rationale and asking, and personally, I don't see any, I have no issue with that, because the master plan, it's very obvious from the topographical maps that the easement has been placed on a very steep area that you probably have to build a bridge, and, you know,
Yeah.
it's.
Could I add to that real
or
quick?
it would take a lot of engineering just
Yes,
to.
just to.
I like to,
yes.
yeah, I like to add to
level
what
it
she
out,
just brought up,
Fill it up.
because, Magay, if, for instance, we do approve this, we just don't wanna have two easements going to our property, and then, oh, this one still, you know, stands here, so now we got
Yeah,
two
we don't
pieces,
want
yeah.
to. We
So you wanna make sure that,
that-
hey, we're adding this stick, we gotta take away.
And I just
that.
want to make sure that,
That doesn't just stay in there, and we already gave, yeah.
correct,
Correct.
right,
Yeah.
that's,
And so that's why I was saying for scheme A, see this where my cursor is moving? A excludes any connection for this easement. A would just go here and then down here. It did not continue here for this easement, so that's why for me, I would go with B instead of A.
And the family is asking for B, not A.
No, they're proposing both.
Oh, they're proposing both.
A or B, and then it's up to the board
Oh, I
to
see.
decide
Oh, okay.
which. And if you guys see a better alternative, then you can.
I don't like it at the cliff line, that's for sure. I didn't know that.
But They technically, they have, based on the master plan, there is a proposed easement. But it would go through lot 181-1 and 183-1, and these families are nowhere near probating or surveying, so if we're gonna, wait for them, yeah, they're gonna be landlocked. So, I mean, we've done this before where with the Nelsons, twice. The Nelsons had easements already. They had but it was up a mountain, up a cliff, and so you guys granted it. So these guys are basically asking the same thing, at their cost though. Same with the Nelsons. The map had to be done at the Nelsons' cost. And so, that's basically the same request.
So when we approve one of the schemes, and I'm just assuming this is so that they can access their land, are we going to have to survey this out?
The family should be the one, it would be at their expense to draw the map and draw in the easement.
But even to open the easement, I mean,
To
that,
open the eaves, yeah,
That's up to them.
I mean, the board can do it, but that's, we can because it's crown lands.
right,
We can if we wanted to, but I let them know that, we really aren't at that point yet where we can open up the
Yeah,
easement, so, again, it's on paper, there's an easement, but as far as actually opening it, there's no
I'm
promise.
just kind of wondering if this obligates us to provide that.
To open it up.
Open it, no, no,
I don't think so.
we're not obligated.
I hope
to.
not, yeah, that would be a condition of the approval that, they understand that the commission would not bear any costs, for this because, it's for their benefit, and so if they want to be able to access their property, they would need to do the mapping and, anything associated with opening and, leveling, 'cause I'm sure there's going to be pockets, areas here where their terrain is still pretty rough, but we're not going to be held responsible for developing an accessible easement.
I don't see how that'll work. If, like, for instance, I had a piece of property and I granted an easement to the neighbor at the back. And I would have to, it's on my property, I would think I'm automatically, right, not obligated to develop the easement, or road back there. Right, it's my property,
Well,
I'm allowing you to go back there,
We're granting it, but we're
but
not,
we're
we're not
you granted
agreeing
me
to.
access, you should open it.
Yeah, but when you grant someone an easement, you actually, unless it's just typically you actually give up that section of land, so it's no longer yours.
Yes,
Because you've given it,
that's right,
to them, so it's up to them.
yeah,
It's up to them.
yeah.
To
So I
be
don't
able
think
to-
that's gonna matter if we
Is
put
it
it in
a
the
public
document or not.
But
easement?
this
Are
is
we
gonna-
granting a
That's a
public?
This is
public-
gonna be a public
That's a public
easement,
easement,
but
yes.
even so, I don't think we bear the responsibility.
Yes, it's a public
Okay.
easement.
Yeah, for, to open.
Here's a question that I have though, real quick. For instance, that's a conceptual, right? But it is registered easement. And these guys just go ahead and start developing and going in and opening up that easement.
There's a process, and I think
It's not, it doesn't belong to them.
yeah,
If we approved it right now, that, okay, you can go through here, what we're doing approving today, because, and they're ready to go to their property, can they just now use that and just go in? Or they still have processes to do with land management?
if it's a clearing and grading, it's a process.
That's what I mean, even though we're granting this,
The DPW,
Process,
and they're
right.
ready, no, but I mean, can they just,
but
okay,
it's
now,
public, but it's public.
are we granting it a public access? If we did it,
No, it's just a master plan.
master plan,
For land management, in the event these landowners start subdividing, they can follow a plan to make sure that nobody's landlocked, because the law says you cannot make anybody landlocked. Right? When you subdivide a property, you're supposed to allow access to a neighbor. In the past, because there was no plan, whenever somebody was returned land, like in Radio Barragata, and they subdivided, they just did a cul-de-sac. And we always ask land manager, why did you approve that, you know, and they said, well, there's no master plan. If we knew a master plan that could follow, then we would, you know, make sure that there's a road plan, so that's why, you know, that's why we came up with these master plans. You know, again, it's just, it's a plan for future development.
But the point was brought up as far as this will be a public. Because once we give it up, it's not Crown Lands anymore, we're not responsible for it, and it's not an easement exclusive to the families, to not, so it is in essence, it's a public.
The ancestral lands would eventually dedicate it to the government of Guam.
Okay.
Yeah.
Okay.
But it's
Okay, I
still.
think I understand that now,
ancestral
yeah,
land.
still ancestral.
Lands until we
Oh, wait, but
So-
no, it cannot be, because if it's still ancestral lands, I don't want to be held responsible for any injuries or anything that may happen for anybody using that. That's what I don't want to see us going down, so.
So with easements, right, from my understanding, easements, you still own the land. But you're giving authorization for the usage to anybody. So,
Not if it's a public, if it becomes public, then the
if you
government
give
is
it up to,
responsible,
if
yeah.
you, so there's different types of easements.
Yeah, you're right, there are different types of easements, but in this case, for the Guam Ancestral Lands Commission, if I am of the opinion, if we grant easements across Crown lands, that liability for any of those easements should not, we're not assuming responsibility or future liabilities to it. And that's
I think that's for every, anyway.
Yeah.
I'm just my guess.
not if it's still considered a non-government owned easement, then it becomes still the easement of whoever granted it. If it's still under their name, then it can open up a can of worms, you know, later on if something should happen. Because I know that in the law that every property owner has a responsibility to, for areas that are open to the public, to safeguard against any kind of injuries. You know, if somebody should, you know, fall or die or get hurt, you know, a person from the public who's using that access can. I'm not saying it'll happen, okay, but can, you know, seek recourse or claims against a property owner. And so I just want to make sure, I want to help them. I just want to make sure that in doing so, that we, because it's coming across properties that are under Guam Ancestral Lands, that we're not going to be held responsible or liable for anything in the future.
And then I
That's
think
all.
it's a good idea to, since we're agreeing to provide a better access, can't we just say if we want it to be a public access or private?
Something.
I believe it's gonna be a public access.
Mhm. I would just want clarification
It
on
should
that,
be.
you know, yeah, right? Because
should be.
it should be, because you said earlier,
We want
any
others to
subsequent
traverse.
subdivisions would have to use that as the reference, because I don't want to see every property owner coming in saying, well, I want it this way. I want it across this way, and pretty soon we've got a mirage of easements going across, you know.
Well, I mean, I don't think we can stop anybody from requesting it, but you have the right to say yes and no. So, you know, you can deny it if you know, but, I mean, we're just, you know, it's just a request that you guys,
Understood.
can
You're right.
grant or not.
You're right.
Vice Chair has.
I have a comment. I'm assuming, with regards to master plans, okay, or easements, those are based on considerations for placement of utilities.
Not
And,
necessarily.
yes, they would, in a plan that would do it, that would suffice all landowners within that area. In the event that the utilities would come in, you know, what do you call it? The thing-
Utilities, well,
Yeah, the sewer, water, and all of that. Based on that. That's how I'd figure master plans would do that. So that everyone would have equal, and then because once they do the utilities, that's when the roads will be built in. To formulate that, based on government doing that, those projects at a master plan level. That's my understanding.
So what the board requested land management to do was to the minimum. Because you guys didn't want to give up 100-foot wide easements. So you guys said do the minimum. And this, yeah, 40 feet.
I want to add one more thing, regarding the master plan. One, just, it's already going through our property.
Yeah.
Does that already automatically have some liabilities that that we are, gonna be liable for? So, I mean, it's theirs on our property, or does that automatically mean, okay, well, we're liable for anything that, Commissioner Weston said? So if we grant that we want the easement actually to go this way and it's yet not formalized, we're still gonna be responsible? Because if we're responsible there, then we're responsible here?
No,
We're
but
not responsible
it'll be
because we didn't.
formalized because the family will.
I'll talk about our liability that Commissioner Weston brought up. From the concerns of the liability. Right now, do we have any liabilities on this master plan because it's going to our property? But yet, if we
That
say,
then that would apply to
then
all other
then
easements.
even if we moved it and said we want it here, then we still got liabilities.
Liability from.
Well, whatever she brought up on the liabilities.
I'm just asking the question.
Yeah.
Yeah,
Are
because,
we liable for what happens on the easement?
yeah, since you said that
No,
the
because
easement would still be under Guam Ancestral Lands Commission.
So you have easements where the land still belongs to you, but the right to use it is to the public. So for instance, the Navy, they return land with easements. When we ask them, since this easement is not being used anymore, can you return that back to ancestral lands? Their response is, we did return the land back. The land belongs to Gov Guam, but we're preserving the easement, the use of the easement. So again, and then, but they also do additional conditions where if you want to move the easement, you have to, if you want to use it other than what we're going to use it for, then it's going to be at your cost. So again, there's so many types of easements.
I know.
There was a radar one.
You'll see on the tax roll too, on Guavan.
Yeah.
You'll see right of way listed under that landowner, but they're not paying taxes on it. So it depends on how you grant the easement, what type of easement you give, if so it just, depends, I guess.
Okay, so I guess I would want clarification just to make sure that whatever easement we may grant through these crown properties would
I don't see how
hold
that
Guam
holds
ancestral
Guam
lands
ancestral lands
harmless.
liable and separates us from these other landowners when they give up their easements. What's the difference? Are you saying that they should also be liable if they give up an easement? To me, that's what I'm saying.
I'm not, I
Yeah.
just want to protect the interest of the Guam Ancestral Lands Commission to make sure, that, whatever we grant through properties that we hold, that we are not, that they are somehow, there's documented that it is it becomes a public access. And, as you said earlier, the federal government said when we gave it back to you, we gave it to Guam. We did, so Guam is the whole, entity, and that it's not just one ancestral lands.
I think
Mr.
once
Chairman?
it's formalized as a actual easement, then we're free and clear, but if it's just conceptual, I'm on mute.
Mr. Chairman,
Okay,
Attorney.
30 Miller? What, I'm sorry, I can't, it's not working.
Anything?
if, if I can pipe in here and just frankly, just sort of amplify the previous point about, we can craft an easement to accomplish whatever objectives the commission wants to set. You have today, you have liability for
Cliffside.
negligent, negligent and dangerous risks on your property, whether there's an easement there or not. The risk you create by granting the easement is, in theory, more people will be crossing your property, and with more people crossing your property, there is a risk of more people finding some way to injure themselves. Now, that being said, we could, for example, craft an easement that says that these other property owners have the right to access their property across Guam Ancestral's property. However, the property owner who benefits from the easement has the legal duty to maintain the easement, and they take all the risk of something bad happening for failure to maintain the easement. My point is, we can condition the use of the easement in almost any way you think is appropriate and prudent.
But that doesn't secure them a permanent easement on the property for their access to their property. It doesn't, right now, this is a permanent easement that we're hoping to grant them through our property.
Correct, but you can condition.
To see it to them. No, I mean, to give it to them, right?
No, we're
No,
not.
I mean, it's public, to give it to the public.
We're not giving
We're
it to
just
them.
realigning the easement
Yes.
of the master plan. And then what they're gonna do is they're gonna actually survey where, or at least draw the proposed on a map.
Yeah, but what our legal counsel is saying, we're just giving them an access easement right now, and it's, though we still own it, it's like, I don't know how they can use that to really, or their hope is for GTA, for Department of Land Management to formalize it and then recognize we want this to be the easement access and make it public.
Is it fair to ask the intent of this? Is it fair to ask, is this for traversing
Subdivision.
or utility easement or?
Or subdivision, and purposes for subdivision.
For me, it's
For
still,
public access and.
so they can drive up to their property and have access to their property, right? You wanna drive up every day, go
So
to
can we
your.
just be specific about that then? We'll grant it or,
Public access.
right, a right of way? Is that how you frame that?
With the terms that Attorney Miller just explained, as far as to minimize liability.
But is that normal though? I've never seen anybody do that why does that only apply to us? I don't understand, you know what I mean? Why doesn't anybody else include that in when they subdivide their property? Why, I don't understand why it has to, why do we have to do it when it's done in the past and it's never been needed? I don't understand, you know what I mean? I don't understand where somebody subdivides their property, And then now we have to worry about, oh shoot, somebody drove off the side of the road and now I'm responsible because they crashed using an easement that I gave up to the public. I don't understand, we've never been needed before.
I guess it's because you're telling me that usually those easements become recorded on maps. And, my understanding is that that it's still conceptual, it's not actually gonna be recorded because everything else is still, I guess, can be moved around very easily, which in a normal situation, you can't, because once it's recorded, it's done. And it's gonna, if you're gonna move any easements, you gotta go back in, hire surveyors, it's gotta be.
It's not an
so-
easement, it's a master plan for land management. When this subdivision of these properties come into play, then they will know, okay, this person is landlocked, we will connect them. Ancestral lands from the beginning should not have, they should have master planned these lands before they were returned.
That's right.
I
But they
agree.
don't,
I
they
agree.
didn't.
I agree.
So now we're having problems, we're not following the subdivision.
Yeah.
So again, you know,
Land
this is
up
the
yourself.
fault of ancestral lands to begin with. The board members were told by land management, do not give land back that are landlocked. We had a former board member, Tony Sablan, saying, why are we giving these lands back to somebody when it's landlocked? It's useless. But the board said, no, we can't do that because that's another taking. Let them work with each other. Oh, yeah, you know, go ahead. Can I pass? No, that doesn't work that way. So we're in a mess that we put ourselves in. And we're trying to fix it. And this is the way that land management said that they will work with us. Otherwise, somebody's gonna record their map and they're just gonna put a cul-de-sac again. And the one behind us will be landlocked because again, there's no master plan. So that's what they said. If we provide them a master plan, then in the future, whenever anybody surveys and subdivides, then we'll provide access. Otherwise, everybody's gonna be.
So in my opinion,
landlocked.
this is a highway master plan, right? Highway?
No, it's not a highway, it's
It's
just a
a-
master plan.
Well, the one we did for, the one that we did, that was done for Radio Barrigada, that's a highway master.
It's the same, it's a proposed master.
I have the document and it says highway master plan on it from, when they were doing it. And then the one from, Cliffline up there was another highway.
The
master plan.
highway master plan, yeah, that was a highway master plan that the board shot down.
Yeah, but this one is not a highway master.
No.
What is it?
It's just an easement,
Just an
it's a
easement.
road access.
Yeah.
Assume it would be
It's
an
not-
access for everybody.
Yeah, just for planning.
That's
Yeah,
it.
But,
That's how I
but
understand.
for all intents and purposes, it's to provide a highway road.
Well,
basically,
basically,
yeah, to-
not
to
the
drive
the
up
term
to-
is.
but to drive up
yeah,
to
it's
their
just
property.
a drive.
I mean, what is it, like, it ain't no book or two or 4 feet or something like that, and they're gonna, what, they could force up there.
No, again, it's for land management.
Have a basis.
When somebody subdivides the property, then they'll say, okay, this guy was landlocked, here's the master plan. We will make sure that there's an easement leading to the back of this lot. Otherwise, again, they're just gonna, oh, I'm gonna subdivide my property, do a cul-de-sac,
Yeah.
and that's it.
And that has happened.
And that has happened.
And,
numerous times.
and they don't want to give up.
No, they
The
don't.
other
wanna give up.
landlords don't want to give
And
up.
you can force them, you can say, hey, this.
But it's really,
subdivision law
it's out of
says
our
you're
hands
supposed to-"
already.
But land management say, so what, based on what master plan?
Yeah.
If I may just say something.
I can't really hear it. What was that? I'm sorry. Excuse me.
Jerry.
If I can just say something, if that's okay. Okay, so yeah, I hear all the concerns and I see all the different insights you guys all have. And I think with our family, it's just been so long, such a long process for us to get this all settled. And whatever you decide, if we have to be guinea pigs for whatever will take precedent, we'll go ahead and try it out.
Yeah, I got a question. How big is our property?
That's about 16, 17, 18,
19
19
acres.
18 acres.
So it's pretty big.
Yeah,
And
we've been, this went through our parents.
Both.
Yeah. So our parents didn't get a chance to see it through. So, us, our generation is trying to see it through. And we're getting up there in our age. And we're just trying to settle everything so the four families can finally just get their property and, do what it is that they want to do.
Well, almost everybody's,
The same situation, I'm sure. Yeah.
Yeah, that was my thought.
No, you were talking about how big was the property, the viability of our.
Yeah, for our, just to protect our ranches, are we okay with it as that?
So
If
for
we
me,
allow it?
I hate to be blunt, but you guys did it for the Nelsons and you did it twice. What's the difference? They had access.
Okay.
Why are we nitpicking now? It's for the benefit of the landowner.
Okay.
And the existing easement, it's not feasible.
Yeah.
You granted it to the Nelsons, no problem.
I think we're just trying to find the best way forward.
We also did it to another property.
Yeah, so.
And I'm just trying to understand, if there are any, consequences to these decisions. That's all, just.
The consequence of leaving the as is you're gonna have, to me, a nightmare of opening the road using the existing.
So it's not a matter of not providing an access, of usable access, because.
Yeah.
Again,
Because
that's the same thing with the
yeah.
Nelsons. They had that
Yeah.
easement, so what's the difference?
It's a usable access.
Yeah.
They had existing utility poles in that access that they requested.
For me.
No, but that was an easement that wasn't granted to them.
That was a Navy easement, Navy utilities.
No, they had private access.
Oh.
But they wanted easement through ancestral lands to make it easier.
But there was utility, but there were poles there,
Yeah.
right, existing. Yeah.
But
That wasn't a documented easement.
Yeah, that's right, it was a
But,
military.
yeah, the concern he had about was how would it affect us if we wanted to RFP the property or develop the property? And for me, I don't really see a detriment on it. It provides an access going up. It clears the cliff line up.
Yeah.
I'm saying for
No,
me,
no problem.
I'm not saying, yeah, it clears the cliff line up.
Good too. Remember, Joey, when the Nelsons asked for that access, my concern is it going to create a problem for future development?
Yeah,
Exactly.
yeah, and if I may add, yeah, and if you do, now you do the roading, put it in the house, actually, that's beneficial part of it. Once you bring in Salani, the people will have that access. Okay, no problem with me.
I think we all agree that we want to.
Right.
But again, my point was basically just since it's not an actual conveyance, out and along ancestral lands. I just want to make sure that we limit our exposure to liability. Attorney Miller has already said that how that can be accomplished. Okay, by putting caveats in the granting of that we're not responsible for development of the property, that the people who benefit from this are, that will carry on down to whoever may tie into this at such time that the access is actually dedicated.
So then we're in trouble then with the Nelsons then, because the Nelsons are using the property right now. And they've been using it, so. Should we stop the Nelsons from using the easement? Because they still haven't submitted a map yet.
Okay, my question is this real quick. Are we granting an easement to them or are we saying
No.
are we saying like to have,
Relocating the existing.
land
easement.
management, because we gotta go to land management. Can't you alter that this is the conception, we would like to go this way? As opposed to granting them an easement through it.
It's just relocating.
Yeah, so that's basically to land management saying, we'd like to have you relocate this way, right?
So when they come in to put in their own road, right? So I'm assuming they don't have their road yet. When they go in to put their own road, this is gonna show up so that it shows how to connect. This is the approved easement to this area.
Yeah, so in essence, we're gonna let land management know that this is how we prefer.
We would have to
prefer-
record a document.
Yeah, and
Which
say,
their surveyor is preparing, correct?
Yeah, I would have them prepare it.
That's, and I wanted to be clear about that. That's why I'm like, well, what does this expose us to if we agree to putting the easement? Do we have to open it? Because there's no,
It's just-
and I'm just, and okay, thank you for your answer. And that's all it's a yes, sir.
It's kind of like the same as what he was saying with Nelson.
It's not, and I'm not talking about liability. I'm also talking about, well, I'm assuming we're talking about this today because it's not something 100 years from now. It's probably sooner than that they would like to use their property.
Yeah, yes. Exactly.
Not getting any younger.
Agreed.
So, I mean,
Shall we move in it?
yeah, if
I'm fine with it.
if
I'm
it'll
good with
help
it.
with, I mean, you guys, signed a resolution of adopting this, and within the resolution, it says that, you allow the adjustment. So.
Based on the request.
Yeah,
And based on a survey, because I think we're gonna have to reference something,
Let's name 40 foot. Right?
there's
Let's name
specific.
it as 40 foot.
Yeah.
so maybe I should have started out the presentation by reading the resolution.
That'll be great. Where is it? We don't,
No, it's not. in
So
there.
I can share it on the screen.
So we're adopting a resolution.
So that.
No, it was a,
You can go over because we're just about to.
prior.
We wanna- Well, if we have any issues and we can't move in it right now,
Well, do you mind just giving them, it might take just 30 minutes
I know,
to tie this up.
she has to leave.
So we're gonna suspend this
All right, then
conversation.
we can continue without you.
Yes, sir.
Yes?
Joey's here.
Okay. So, our director's asking to be excused. So,
Right.
okay. Okay. Be safe.
I don't have any problem.
I don't know. Joe, can you read,
So-
you better read the
Okay.
resolution. Joey's gonna read the resolution.
So here's the resolution, Guam and Central Lands Commission Resolution Number 2018-05. This was recorded, under instrument number 929-970. Whereas the Guam and Central Lands Commission hereafter GALC maintains the fundamental authority over returned lands from federal possession pursuant to the Guam Excess Lands Act, and whereas the GALC, through support provided by the Department of Land Management, has identified road easements, go-kart trails, and public access as to determine such access or easement locations in relation to the return subject lot that is landlocked pursuant to Public Law 31-134, and whereas the GALC desires to design a series of easements through lands as described in Public Law 31-134, whereby extending beyond such lands in anticipation of the return of other adjoining properties, and whereas the GALC desires to create an easement master plan for such areas for the purpose of complying with and adhering to the subdivision law of Guam as prescribed under Title 21 Guam Code Annotated Chapter 62. And whereas such master plan purposely indicates proposed dotted
Yeah.
easements ways to convey flexibility
Right.
and the opportunity to exact readjustments depending on certain physical attributes and characteristics each parcel of land. Now therefore be resolved, the Guam Essential Lands Commission adopts the tentative master plan Upper Harbor Reservation V-2 GALC rights of way plat phase 1 as noted as Exhibit A. Duly and regularly adopted by the Guam Essential Lands Commission this 28th day of November 2018, and it's signed by the chairperson, the secretary, and the director at the time. And then Exhibit A is the master plan. So again, it was just, it's just
Yeah.
to plan
It's
for
clear.
the future subdivision and to make sure that, hopefully nobody is left being landlocked. And so with this, land management can now follow some sort of plan when and if these landowners start subdividing. And like I said, I mentioned it again before earlier, they have an easement here, through here and here, but these landowners, we do not foresee them surveying. I mean, they haven't even started probate yet. So, the county in front of you have already subdivided the property. They're pretty much done with their probate. They want to start using their land, but they're landlocked. And so that is why they're coming before the board.
Yeah.
And the law says that,
It says
we're
that.
required to provide access to landlocked families through government land, but at the expense of the requestor.
Right. And it also says there on the last whereas that they have the flexibility to make the adjustments. That's where we come into play.
And Joey, if I recall, there's also the bill from Senator Ada that, for Polaris Point, there was some kind of infrastructure, what do you call it, the infrastructure fund that was aimed at some of those places in Barragata, remember?
Yeah, so, eventually, if the board wants, they can use the survey infrastructure development to open up easements to crown lands.
Right.
This is a crown land. So again, if the board wants, they could develop this easement if they wanted to.
Right.
They cannot open the easements which are not within the crown lands.
And that's the purpose of that infrastructure.
Survey
That was good. It was by the legislature that gave us that authority.
But,
We don't have
that's
to.
something
There,
that
we
we
can.
in the future, if you guys wanna look into it.
It was mainly to facilitate and help the landowners who we gave their lands back. They have issues, problems.
And it's in the resolution.
Yeah.
Based on the physical attributes and the characteristics of the land.
So,
And
yeah,
that's what it
I'm
is.
not afraid to admit that, we made a mistake.
Yeah, we've
not
made a lot of
understanding
mistakes.
this
Yeah.
Before we return it back.
Let me clarify to that. Remember, this Guam Ancestral Lands Commission is a very unique commission. Very few in the world have this. So we did make a lot of mistakes. We've done that for age, and we regret, we've gotten almost sued individually, personally. So that's why we're looking at it, we're looking at it but we're here to help. So I'm in support to help you to have your access, because once you do the roads, now that will allow access for us too, and everybody else. And and we're dying. So I have no questions about it, and just take pictures when you're done. And let us see your road, man.
But and look at it, if we were to develop the easement ourselves.
Yeah, that's right.
That would be more cost to us.
Yeah,
if we
I
follow
agree.
The the current.
I agree. I agree. And it says there, tell on the resolution there that we, it's based on the certain physical attributes which is contained, no, padron, right? So, and we want you to utilize your lands. That's my, everyone's, but you're starting it, you're making that effort. Yeah, I have no problem.
Yeah.
And it'll make to me, it would make the property more marketable.
That's right. I agree. And we get to see the property because we get to drive in with you guys.
Yeah, for me, proposal B, because A does not address
So
the
we'll do
other lot that
proposal
will
B.
still be landlocked. Yeah. So it will take up more acreage. But again, I mean, for us, it's crown lands, and the purpose of us is to provide access to landowners
Right.
that are landlocked. You know,
And we don't want to get involved in those landlocking. I'm okay.
but I hear and I agree with Commissioner Weston that, you know, if.
Yeah,
we
it's gonna
need
supersede.
to Word, if, you know, I will, you know,
Work with it.
see if we need to. You know, word the document
That. Yeah.
is to.
Effectuate.
reduce any liability to
Yeah,
ancestral
that's
assets.
right.
You know, I'll look into that.
But you know, for,
We appreciate that truly.
Yeah.
And, you know, I am on board with everybody else
Yeah.
as far as helping, you know, create better access, but I just, as you said earlier, in the past, boards passed things that later boards
yeah,
came back to, you know, to nip us in the bud. And I just don't want to see that happen again.
Yeah.
And Willer has already stated, what our potential liabilities can be, but how we can also, minimize that. And so that's what I would hope that we would move to do, at the same time, to help the property owners around there.
okay. Through my experience now with any property, if in the event any accident or any occurrence happens in your property, no matter what, signs, even if you have signs of warning, the liability is there on the owner, no matter what. In the court of ruling, the landowner is responsible. Even if you have signs there that warning, hazardous, all of that, in the event any accident, the title holder is liable.
It might be who's negligent. I think that's just.
It doesn't matter.
If a burglar in California.
It doesn't
state
matter.
Comes through your window and he steps on the door and falls down, he can sue you. because you're at your
right.
door.
Yeah.
And that's no joke
Yeah,
in some
and we've
states.
experienced that with our properties with the Young Men's League of Guam. Even if you have a sign there saying danger this, danger that, you're still liable.
But isn't it just prudent to put it there and
Yeah,
deal with it as it comes? I think it's.
that was only a statement of fact that I, if through my experience, that's all I'm saying.
He's not saying not to put it in. Enjoy
Yeah,
the fight in
I'm
there,
just
put
saying,
it in.
yeah,
Put it in.
if based on the attorney's request also. Okay? I have no problem.
Any
So
further?
I guess
Let's
the
move.
decision for the board then is,
Plan B,
are you, do you?
Yeah.
Are you okay with?
Plan B?
A or B?
What the big B, you're suggesting B,
I suggest with B.
okay? Based, yeah, let's go. So shall we vote on it?
No, so, is it
I'll
a
move.
motion or a resolution?
I move.
Motion.
I move,
Okay.
based on the heavy discussion and for the benefit of our applicants here for access, I move that we approve the adjustment of the easement based on Joey's, Plan B recommendation.
Okay, we have a motion on the floor to approve the request by our applicants here. By Vice Chair. Do we have a second? Seconded by Commissioner Cruz, okay, and all in favor, aye?
Aye.
Aye. Any nays? No nays, Joey. So it passes.
Okay,
Motion
Thank you,
passes.
commissioners.
there you go.
It's passed.
That's the tell.
Thank you. Just Marcy.
Yeah. Okay, you can remove the results. And then on the record, then attach that resolution with everything together, all of those addendums that way, and then highlight the bottom one there, Joey. The whereas where the flexibility is, and it allows that.
So just passing for your appearance today.
Yeah, dispensa chalo ya para tapan na nating ani
Huh?
Ayan na Joey
We will.
Yes, Joey jo sarla esta chalo tapan sige tapan da. Sa Canada ilanala sa tapan da no sige. Sa esta ki mo mela put the palolo then we can do it. But for now, let them.
Yes, of course.
Yeah, that's our role. That's our role.
Hope it works out.
Mission accomplished.
Hope it really works out.
Está hecho.
Joey.
Right on. And then when it's done, we can go in for a drive and check it out
Thank you.
in the next 5 years. No,
Algamas.
right, Joey? Once they do it, we can go in for a property. Anything else?
Work with Attorney Miller on
That matter.
that matter and you know, cause that is, I mean, something very important. as
Did we
far as-
put
Yeah.
that, did we put that in on the,
Based,
Nelson?
yeah,
No,
yeah.
we never did
But
it on the Nelson.
based on the
Final.
original easement map, that's when you're gonna have to place that in, because the liabilities, if he had gone through that as an easement,
How about
that's
the
what he's
past
talking about.
easements? We've done past easements that we've never get, that we've done past.
I
No, we would have
Yeah.
to have it. So, you know, again, but it doesn't mean that's not something that we
Yeah.
can start doing and so I'll look into it.
We're gonna be running into several of those, I'm pretty sure.
But I
More.
wonder if even if we put it in the stipulations, I wonder if that actually absolves us from it. Or just because we put it in there, you know, does it actually?
Better to be safe
Yeah, but-
than.
Yeah,
I wonder,
Better.
And-
You're right, Joey. We did do it in the past.
right.
On us, and so, you know. To move forward, you know, we can correct, to further safeguard.
Yeah,
yeah.
that, you know what the thing about it that strengthened that was the last whereas. You know, to adjust it based on the access, the reasonability of it to get it, and that's the one.
I think there's no question that we have the authority to do this.
Right.
There's no question.
No.
It's just we wanna make sure that,
Because there's the cliff, yeah,
the
that
way
was,
we do it is just the best for
For
moving,
everybody.
yeah.
yeah,
And benefit.
anything else?
Okay, so we're gonna move down to item 5, announcements of next GALC board meeting. I believe our next one is this Friday. I think it's a special meeting, special meeting for
What, Friday?
this Friday for Smithbridge,
March 6th.
March 6th.
Oh, well, this coming Friday,
Yeah, this coming Friday.
yeah, because today's
Then-
Friday.
And then I think after that, I think we have a little bit of a long break for that, the next year.
Hopefully the deed signing,
The signing, okay,
March 6th.
March 6th.
March 6th, yeah, this Friday.
Special.
Special meeting,
Special meeting.
just for
just
Smithbridge,
for Smithbridge.
their request,
Oh, Smithbridge?
yes,
Yes, ma'am.
Oh, I passed by there because they where they really,
yep.
all kinds of structures and everything, but that mountain of debris.
Sorry.
From the highway, right? Yeah.
Well,
Still there?
Did we move to adjourn? Did you call off? Right.
Oh, yeah, it's still there.
Okay.
I took videos.
Oh, okay.
Driving past there and I could still see the mountain.
Okay, so we're gonna go down to item, item 6 and
That's it.
adjournment?
Yeah,
Motion to
I
adjourn?
move, so move. That's it. Don't need to be
What time,
seconded.
what is the time? 4:42, this
Yeah.
meeting is
All
adjourned.
right, there you go. Adios, hasta aquí.
4:42.
Yeah, I got 442.
So just passing. Same thing, 2:30.
So no more 2 o'clock?
There's sometimes where I think I can do a 2 o'clock, but man, it's gonna be tough for me. Yeah, 2:30 is where, and we're just under it right now at 4:42, so we don't wanna go past 5.
Okay.
Okay.
But everybody prefers 2 o'clock, right?
2:30
2:30?
Yeah, 2:30 is good. Yeah, that way, because I was,
Wanna see if I
give me
can.
more time to do more of my errands.
You stop it?
Okay.
I don't know if you can do it.
I
Thank
hear.
you so much, Joe.
All right, it was good, Joey. Yeah, right on.
Everybody, just pass it.
Yeah.
So
Uh,
anyway, I'm interested in those videos that you took, of whatever.
I just drove down slowly, you know, and I was just, really surprised, just amazed at how much.
You know,
Wow.
so what was the special, what's their special, request? Do you have?
A couple other things. They're also asking to temporarily lease out.
That center part, that one middle part?
Yeah, until we are able to.
That's what they think.
No.
Is it? Yeah, there's paper, yeah, is there not, they're trying to take over like I was, see,
It's not.
who's that guy? Who's the one that keeps tricking us?
See,
Pearson?
Pearson, I think, but he asked to redo it. Oh, there you go.
Yeah.
It's.
Oh,
wow, let's do that.
So I was just driving with my son.
Okay.
So you can see they put up this.
Yes, that's a great
big
thing.
Crane thing, and then now they'll have. So there's.
Containers?
I don't know what these are, maybe.
Oh, wow.
bottles or something.
Yeah, no,
or-
yeah, those are batching plant. That's the
Batching
batching
plant,
plant. That's a
okay.
batching plant
What do you mean batching?
for cement.
For their
Oh.
cement, yeah.